dare we get rid of a tariff? Come on.
Okay, I'm unmuting everybody.
Over there.
Good afternoon, everyone. Please take your seats. And if you can't find a seat, welcome to the Public Utilities Commission. I wanted to point out that the small hearing room, which is located behind us, has additional seating and video monitors if there's not a seat for you and you would like to watch. Today is September 26, 2024. This is an agenda meeting in the Minnesota Public Utilities Commission. My name is Katie Sieben. I'm the chair of the commission. I will now take the role of the other commissioners who are present for today's hearing. Commissioner Means. Here. Commissioner Hom.
Here.
Commissioner Sullivan.
Here.
And Commissioner Tuma.
Here.
A quorum is present, and we will take our votes by voice acclamation due to everyone being, all the commissioners being online, but we also welcome the participation of people who are joining us on our webcast. We have two items up today, and I know the second item has particularly a lot of interest. It is our intention to adjourn the hearing today by 4 o'clock. Our first item was analyzed by Nikki Brown-Huss. Ms. Brown-Huss, when you're ready, please introduce item number 1.
Good afternoon, Chair Sieben and Commissioners. Item number 1 is docket E002M24147 in the matter of Northern States Power Company doing business as Xcel Energy's annual report on its Renewable Connect pilot and flex programs. The question before the Commission is, should the Commission accept Renewable Connect pilot and flex program compliance filing and tracker report and approve the associated revised tariff sheets, rates, and neutrality charges? I have no further remarks, but I am available for questions. Thank you.
Thank you very much, Ms. Brown-Huss. Commissioners, we don't have opening statements. Are there questions for either the department or Xcel? Commissioner Tuma?
I didn't know if the department came up here because I had some concerns, but I can make a motion real quick, so, okay.
I just really like these seats.
Okay. You wanted to get a jump on the seats. I got it.
And we're available for questions.
Oh, that's right. Thank you for being available, Madam Chair. I would move 1 and 3.
Commissioner Tuma moves decision options 1 and 3. Is there any discussion of the motion? Hearing none, all in favor, please say aye. Aye. Opposed, the motion prevails. Thank you very much. Thank you to the parties. Item number 2, Mr. Northagen and Ms. Winner, when you're ready, please introduce the item for the commission.
Good afternoon, Chair Sieben and Commissioners. Item number 2 is docket number E-999/CI-23-151 in the matter of an investigation into implementing changes to the Renewable Energy Standard and the newly created carbon-free standard under Minnesota Statute 216B 1691. There are 3 questions before the Commission. First, how should the Commission define carbon-free? Are there any clarifications necessary regarding what resources should be considered carbon-free? Second, how should the Commission consider partial compliance with respect to Minnesota Statute 216B 1691, subdivision 2D-B, including both subpoints 1 and 2? Question number 3, what considerations should the Commission make when operationalizing the definition of environmental justice areas as defined in Minnesota Statute 216B 1691, subdivision 1E? Staff has compiled preferred, modified, and new decision options in the revised decision option 2.0 document and in the revised decision option spreadsheet 2.0. Staff has also provided hard copies of Minnesota Statute 216B 1691 in full. Commissioners have received a copy of the documents, and hard copies are available in the front of the room. Lastly, staff wants to thank all the commenters who participated in this docket for their cooperation and work on these issues. Thank you, and staff is available for questions.
That was a nice introduction. Thank you, Mr. Northagen. I'd also like to thank you and Ms. Winter for your extensive work in summarizing the record that's before the commission, and echo your comments to thank the numerous parties who submitted comments. For those of you who don't normally follow the commission, I just want to assure you that if you submitted a docket or a document into our record, commissioners did review it and did take it into account. So even though we don't always, at our commission hearings, take public comments from commenters, we welcome and appreciate your input into the record. And I also just wanted to say, because this is such an important piece of legislation that the commission is working on, we all, I think I can speak for our staff and my fellow colleagues, we applaud the leadership of the governor and the legislature in passing the carbon-free standard in 2023. This is certainly a foundational piece of our state's energy policy and a signature accomplishment of the 2023 session. And so I'd like to begin this morning or this afternoon, normally we start in the morning, with you, Dr. Lieb. Would you please state your appearance for the record, and as the representative of the administration from the Department of Commerce, please provide remarks to us on how you see the this docket, how we should proceed.
Thanks, Chair Sieben. Sydney Lieb with the Minnesota Department of Commerce. The department has approached this docket from the lens of the administration's goal of achieving net zero carbon emissions by 2050, as stated in 21602 Subdivision 1. This statute provides an important tool to achieve this goal by decarbonizing the state's electricity supply and further enabling decarbonization of other sectors through electrification. The law identifies clearly three categories of generation technology: those that are fully carbon emitting, such as traditional fossil resources, those that are fully carbon free, and those that are partially carbon free. All of these resources are intended to create a generation mix that gradually transitions to 100% carbon free in 2040. We've submitted a group of decision options that I believe were submitted by a large number of other parties in the space. We are recommending that the plain language definition of carbon free, which is a technology that generates electricity without emitting carbon. We disagree with the PUC's contention that a plain language reading of the statute is that carbon dioxide emissions are measured at the point of electricity generation. The statute does not need to be ambiguous here in order for the Commission to detail criteria and standards to measure an electric utility's efforts to meet the standards, including partial compliance, and to determine whether a utility is achieving the standards. Therefore, we believe that decision option 1 is not an appropriate choice. Further, subdivision 1C provides the definition of eligible energy technologies because the statute instructs us to use these definitions through section 2 and modified, or we're supporting decision options 2 and 3 as modified. The legislature always intended the entire statute to be effective and certain. We use the energy technology standard initially overlapping with the ETS and then fully converting to the carbon-free standard, meaning that utilities are meant to meet the eligible technology standard up until the 2030s, and then we are intending to have a seamless transition over to the carbon-free standard. Recognizing that the utilities are meeting the first standard with resources that have a long life, often 50 plus years, and the timelines associated with utility scale resources, it's logical to choose decision option 2, which allows the carbon-free standard to build off of the eligible technology standard, not to create some sort of compliance cliff between the two. The stated intention of the statute is to reduce carbon emissions from the electric sector, and adopting what the PUC said is a plain English interpretation of the definition of carbon-free decision option 1, would have an absurd result of incentivizing use of hydrogen that emits significant emissions when produced from coal or natural gas, while producing no emissions at the point of no carbon emissions at the point of generation, would result in significant carbon emissions being entered into the overall economy, and would be an absurd result of the implementation of this statute. One of the fundamental canons of statutory construction is that legislature never intends a result that is absurd, impossible of execution, or unreasonable. To assess partial credit, we're recommending a life cycle approach be taken for those combusted resources that emit some amount of carbon. We're recommending that that life cycle assessment be moved to a separate docket. Life cycle analyses are inherently complicated, depend on the fuel supply chains, depend heavily on what the alternative uses of those fuels could feasibly be and how carbon may or may not be emitted in those use cases. And there's insufficient record development in this record for us to come up with a robust discussion and determination of how carbon partial credit should be assigned to those resources that undergo a life cycle counting. And otherwise, we're recommending that partial credit be given for carbon capture and sequestration. We believe this is well supported by both the existing statutory language and the legislative record that's associated with the passage of this policy, and that purchases from the RTOs or from PPAs be assigned an appropriate carbon intensity for unspecified power purchases based on the RTO, an appropriate RTO grid mix. And in cases where the purchase is known, such as a PPA, the emissions should be assigned given where we know that those electrons or generation energy is coming from. And that is our overall view on how we believe this should be implemented. We believe that this is an appropriate way to implement the rule that will enable the state to achieve its decarbonization goals without unintended consequences of allowing for large amounts of dirty emitting hydrogen into the electric sector.
And Dr. Lieb, thank you for those comments. So the department's preferred decision options are correct and clarified in the revised decision options sheet? Or is there any clarity you'd like to provide?
Chair Sieben, the only additional point of clarity that we would like to provide, everything is correct. We are open to 20 or 21. That just has to do with which grid mix specifically is used for the RTO, whether it's the full MISO market or just MISO North,
And is that something that you anticipate we would need to make a decision on now, or could that be made later?
The department believes that there's sufficient discussion of how the power market sales should be determined in this record. So I think while we're supporting 19, that we might want to build out a little bit more of the calculation methodology and compliance instruments in the next docket probably on how we should net and account for the market sales and purchases. I think we're supportive that once we have that figured out, we can make a decision today that the purchases can be applied an appropriate grid mix based on the RTO.
I just have a quick follow-up on that, Dr. Lieb. How would you envision, I mean, the MISO mix is getting cleaner by the year, so it would not be fair to apply a metric going forward. So how would you imagine that would be included in the analysis, that just to account for the fact that the MISO system is getting cleaner?
Sorry, clarification, Chair Sieben, Commissioner Sullivan. Are you talking about in projecting compliance?
Mm-hmm. Yep.
I think,
or is that a subject that would be discussed in the methodology?
the department, I think, believes that's probably more appropriate for discussion in the next docket, which I believe has been teed up on exactly how we're calculating compliance.
Okay, thanks.
What would that be done annually? That's a.
Turn your microphone on. Commissioner Tuma.
I'm somewhat confused. Commissioner Sullivan, because wouldn't we get annual filings about compliance? We do right now for renewable energy, so they would come in and say, oh, by the way, now MISO is better, so I don't have to go out and buy as many credits to meet the, I mean, we would know that annually going forward. It's not like a static determined now for on in
That's
the
what I was
future.
just trying to figure out.
Oh, okay, that's why I was confused.
Commissioner Hahn.
Thank you, Chair Stephen. So even though MISO is our major player as an RTO in Minnesota, we have other RTO serving Minnesota load, and then some utility belong to SPP is serving our load. So I agree that we can delay this clarification on this issue in the later docket, but I think we need to develop more record based on the multiple RTO, and also at times MISO is importing like 9 to 10,000 megawatts from outside MISO. So I think we need to develop more record based on those facts, and hopefully department can engage on that.
Chair Sieben, Commissioner Hom, I think the department agrees figuring out the exact nuts and bolts and compliance calculations that need to occur, looking at what data is available in the various power markets, and also how carefully utilities are tracking those purchases and what the reporting requirements would be, is something that needs further record development. And I think we feel like that's probably the appropriate thing to set up in the next docket.
Commissioner Sullivan.
Thank you, Chair Sieben. And I guess this is a question for Dr. Lieb. Might be for somebody else, but just get ready. I mean, I look at this, and I look at the statute 216B.1691, and then in particular where a lot of the discussion in the record is built around, and reviewed the record. It's very full. I appreciate all the work that has gone into this. And I just look at the definition of carbon-free. It's not ambiguous. Why do we need to weigh in at all? Like, it is what it is.
Dr. Lieb.
One or two seems to be, from my perspective, it's too soon. We don't have the record developed around it. The statute is what it is. And when the utilities are going to comply with this, they can read it, just like me. And even if we weighed in on it, doesn't matter. The language is the language. And if you go, I'll let you think through that.
I think just to further build on that, I have a little bit of a hang up, and I'm looking for a different word perhaps besides clarify, notwithstanding any other definition. Because I think what Commissioner Sullivan is getting at is similar to it when reviewing the record here and seeing how parties were commenting on this. The law is the law, and what matters is the implementation of the law. And so how do we provide enough clarity towards future planning, but also not attempt to rewrite the statute through our order? That, I don't know if that's similar to what you were thinking,
you
but
said it better.
Chair Sieben, Commissioner Sullivan, I'm going to let Sarah Payne, my general counsel, address this one. I think this
Ms.
is more
Payne.
of a legal interpretation question.
please state your appearance for the record.
Chair Sieben, my name is Sarah Payne. I'm General Counsel at the Department of Commerce. Thank you for your question. I think the question that both you, Chair, and Commissioner Sullivan raised is a very good one. And I think where there is a little bit of confusion, perhaps, is in looking at the plain language of the statute in 216B, subdivision 1. Mm-hmm. My computer is not as fast as my mouth. Carbon-free is defined as a technology that generates electricity without emitting carbon dioxide. And I think we all agree that that's the plain language of the law. I think when you look at the language that is included in decision option 1, it changes the wording of that. And so that you're no longer looking at the plain language definition, you've changed the definition in decision option 1 to include the language, hang on,
As
carbon dioxide emissions that are measured at the point of electricity generation. And so I think there's probably relatively easy ways to go to pick a path forward. And one would be to change the wording in decision option 1 and recite what the statute lists as the plain language definition of the statute. Or if you want to go with decision option 2, I think you could again, modify the language slightly. I don't think you need the language clarifying the notwithstanding any other definition, because as you both have pointed out, the statute plainly says what it says. And then if you go further down into subdivision 2D, it directs the commission to issue detailed orders that talk about how we are going to measure compliance and partial compliance and set those things out.
Can you say that again? Sorry, I'm distracted. 15 seconds ago, sorry.
Sure. The definition of carbon-free is a plain language reading of generating electricity without emitting carbon dioxide. I don't think you need to get to the question as to whether there's ambiguity or not, because if you modify decision option number 2, you don't need to get to the question of if there's ambiguity. We have the governing plain language of the statute. And then if you scroll down further in 216B, 1691 to subdivision 2D, it directs the commission to issue detailed orders about the criteria and standards that are needed to measure the electric utility's efforts to meet the standards, determine whether a utility is achieving the standards, as well as gauging partial compliance. And so because the statute includes that very specific directive to the commission to provide detailed guidance, you would do that regardless of whether the legislature thought the statute was ambiguous or not, and obviously they wouldn't pass something they thought was ambiguous. But so I think we just don't even need to get to that point to be able to further develop the record to allow you to issue the detailed guidance needed for utilities and for the state to measure compliance and figure out how we are getting into those specific criteria. Did that answer your question a little better?
Yes. I mean, here's where my brain went. I looked at that same section, 2D, commission order, and then under 2DB, sub 2, I think the only thing we need to do today is require that clarify what partial compliance under 2G means. And I would just drop, the statutes are what they are. 1 and 2 seem to be, I appreciate the work that staff has done, and I appreciate the work that has gone into the record, but as I reflect on it, I think we should just start with decision option 3 and do a life cycle analysis. I am concerned about the issue around hydrogen. I think hydrogen at the stack absolutely would be carbon-free under the definition, but you can get hydrogen, just start breaking coal apart. There's lots of hydrogen atoms in those coal molecules, and that is not carbon-free. That would make the carbon-free statute absurd. So I feel like where the record needs to start is just with the carbon cycle analysis, and then I think the commission, my personal perspective is, we should be silent on 1 and 2. And then where this comes to us is it comes to us when utilities file resource plans. Utilities know what's in the statute. They're going to file a resource plan that is compliant with 216. And we need to make a determination of what partial compliance under the carbon-free law. I'm not trying to make this an inquisition, but I feel like this is clear to me.
Madam Chair?
I just 1 second, Commissioner Tuma. I just want to finish this discussion about do we need one or two? Because I think what you said, Ms. Payne, was interesting, that if we struck the first portion of clarify that, any other thing, and then, so to put you on the spot, would you prefer that we tweak the language in 2 to effectuate the conversation you just had with Commissioner Sullivan? Or would you prefer we not adopt decision option 2 at all and skip to the remaining? Because I think I get where you're going, Commissioner Sullivan, but the record developed, and again, I'm trying to, like in my review of this, I'm trying to adhere to what the department wants, because you were an important voice in this docket, and I'm trusting your input. And I appreciate, Dr. Lieb, how you laid out like a path that made sense for my mind of how we would help implement the new statute. So putting you on the spot, and you can say you want more time to think about it, would you prefer that we move forward with some modification of that word clarification in decision option 2, or would you prefer we skip it entirely?
I think that, sorry, I'm just trying to pull up the statute. Multiple screens here.
I mean, I think the benefit of decision option 2, from what I heard Dr. Lieb explain in her opening comments and were in your written reply from June, was the benefit of including the latter part of that helps lead to a logical result, that the EETS technology that is discussed in later parts of the statute will fold into the carbon-free standard. And so that, you know what I mean, Commissioner Sullivan, that is like still a piece.
Here's where I'm hung up on this. Is the language says the commission shall issue necessary orders. Is it necessary? I mean, I think the necessary order today is partial compliance. I don't think there are any other necessary orders or necessary decisions that need to be made. I mean, with regard to 1 or 2, those don't seem to be necessary to me. The statute is what the statute is.
Madam Chair,
Can we let her finish?
let me help her out. I can help her out. I'll give you the answer if you want.
Okay. Commissioner Tuma, and then, but because, did you want to add something to, let's let her answer
No, she
Commissioner
can, but
Sullivan's.
She'll actually appreciate what I'm going to do, because I
Okay,
agree with
but
her completely.
we'll all appreciate what you're going to do, but let's let her speak first.
Chair Steven, no pressure at all on this next answer. In terms of what is necessary for the commission to do, I think the way you just laid it out, Commissioner Sieben, makes the most sense in terms of preserving a seamless transition. In terms of the definitions, so I would agree that I don't believe it is necessary for the commission to make a decision today on whether the statute is ambiguous or not, because we can already read what the plain language definition is.
The trick here, I think, and it's the way the question came to us in the order, and that is like we kind of are wrapping ourselves around that, because that's what we do. And I think this is just worth continuing to think about. So now for the clarity, Commissioner
I
Tuma,
hope I
we're
give
all
you clarity,
waiting
Madam
for.
Chair, and I have thought about this, and I'll work through Ms. Coleman. I was going to work over Mr. Mueller, because he's the one that started me thinking about it with biomass, but it applies to any of the eats. And I think that's where I felt like there was something missing. There was analysis. Everybody got their heads spun around 2D and over the definition of carbon, and they missed the whole of the statute, which is what I think it's case law, State versus Watkins, where it tells us we need to look at the whole of the statute to make it to make sense. And I think people were missing the heart of this statute, and part of it was confused by when you look at Appendix 1. And I think you would disagree with the way our staff laid out Appendix 1. Not our staff, they were just looking at the analysis. But they seemed to put Decision 2 under the ambiguous category. And what I heard Ms. Lieb say, and I totally agree with you, it's not ambiguous. And the part that I think people kind of missed was the heart of this statute is actually Subdivision 7. And I want to walk through Subdivision 7 and 4. And when you look at them in total with the rest of this, it makes perfectly good sense. And I would agree with you, Commissioner Sullivan. It's probably not necessary, but it doesn't hurt to clarify that eats are in. I mean, that's the beginning of this is eats are carbon free. And I think that's very clear. And there was a lot of debate about whether they were, and then we got to do life cycle on them. And it seems like they're clearly in, because when you read Subdivision 7, the essence of it is the commission must, again, the essence of this statute is that it is a accounting exercise about carbon emissions. And so when you read 7, it says the commission must regularly investigate whether the utility is in compliance with the electric utility standard obligations under 2A and 2F, solar and wind, okay? And then the legislature then just dropped this in the bill, and 2G, okay? That's the carbon standard. They didn't create some special carbon accounting, because when you go on, it says, if the commission finds non-compliance, it may order the electric utility to, 1, construct a facility to purchase energy generated by eligible electric technology, or purchase renewable credits and engage in other activities that advance the compliance. That would, to me, we're doing an off-ramp. We're trying to get them on. But I have 3 powers if they come here and they haven't met. Go buy something, okay? Build something, or go get RECs, okay? Those are the things they can do. But when you take those, so if you look at 2G, there's no carbon-free standard, okay? In compliance, I go right back to EATS. It tells me when you follow the thread of this statute, subdivision does not create a carbon-free resource or carbon-free standard. It says, I can order you to build a wind farm, hydrogen facility that uses a wind farm or solar, build solar, okay, biomass, okay, those are the things I can do, order you. I can't order you to do carbon capture. I can't order you to do some other carbon-free thing. Those are the 3 things I can do. And now, when you fold that into 4, now, just Ms. Coleman, I hope you can see that. I want to make sure I'm not missing anything. Do you agree with that basic premises that the heart of this is the compliance? Those are the 3 things I can do. It may involve life cycle stuff when I get to partial compliance, but when I get to non-compliance, here's my authority. It centers around EATS, right?
You're asking Ms. Payne?
Yeah, she's looking confused. I'll slow down.
You're confused on her name.
What?
You said the wrong name. That's Ms. Payne. Or
Payne,
Dr. Lieb.
Why did I get Coleman in my head?
I don't know.
Your general counsel is Ms. Coleman. She's welcome to take a crack.
That's why you look confused. That's okay.
I was a little confused too, but I
I
got
don't
it.
know why I got that in my head, but I did. It's a nice name, though, but both Payne and Coleman. Payne Coleman, okay. Payne, okay. I'm trying to track now. Do you see where I'm going? Is that when you look at the heart of this statute, it doesn't seem to be confusing that EATS is the basis of the compliance, right?
Ms. Payne.
Chair Sieben, Commissioner Tuma. I agree with you to an extent.
Okay.
I think where it gets just a little bit more complicated is that when you are in both subdivision 4 and subdivision 7, they both use the defined terms that are laid out in subdivision 1 in terms of technology and carbon-free. And so it's important that you refer back to the definitions that are set forth for the purposes of the section of 216B 1691 when you're reading through the whole statute.
Well, I'm reading through it. I'm looking at the statute right here, subdivision 7. Okay. Purchase energy generated by eligible energy technologies. Okay. That's defined. That's EATS, right?
Correct.
Purchase renewable energy credits. So let's go to 4. Subdivision 4 says, 4A says the commission must establish a program for renewable energy credits for energy generated by EATS. It cites back to the EATS statute. It doesn't say carbon-free. It doesn't say some other special thing. It goes, again, right to EATS. So you're right. When you look at 4 and you look at 7, everything centers around EATS. And what your decision option 2 was trying to do is clarify that we start from EATS, which I agree with you. But what I agree with, and I think the confusion is that we don't have to, as Appendix 1 of our briefing papers point out, we don't have to go through ambiguity to get to EATS being the beginning point of our definition of how we deal with carbon-free. It starts with EATS. That's what your decision 2 does, and I agree with you. I just wanted to be very clear on the record and in our order that that's because the statute is eminently clear, as Commissioner Sullivan pointed out. And I think when you look at 4 and 7 together, they all point back to EATS. They don't create a separate carbon standard. I can't order Minnesota Power if they're not meeting their obligation to go build a nuclear plant or buy a nuclear credit from 3 Mile Island. They're going to restart the stupid thing after all. So I can't do that, but I could tell them to go buy a credit for a biomass facility in the Big Island of Hawaii where they're burning woody biomass. Could do that. Mr. Mueller, I could do that, couldn't I? You on, Mr. Mueller?
Mr. Mueller, welcome to the commission. Please state your appearance for the record.
Good afternoon, Commissioners. David Mueller from Minnesota Power.
A little bit.
And Jennifer Clinton
Sorry,
from
Mr.
your
Mueller,
call.
just a
Yeah.
second. Can we turn up the volume? You can't tell, but it's a little quiet, so try now, please.
Is that better, Chair Stephen?
Not really.
No. I can turn my headset here, too.
We're turning up the volume in the room. Hopefully it will help.
Okay. Is that better, too?
Yes, thank you.
Okay. Sorry about that.
Did you need Commissioner Tuma to repeat his question?
Yeah, I'm not sure he asked one, but yeah.
You know,
What did he say?
We can't, a little louder, Mr.
I'm sorry, Chair Stephen. Yes, if you could repeat the question, that'd be helpful.
so I'm walking with, and I'm getting to the concern that we could get an absurd result if we try to redefine what you can build under the definition of carbon, neutral or carbon-free, okay, which is you want to build a woody biomass facility in northern Minnesota, right? And if we were to restrict that definition to require limitations on that woody biomass facility not being under the definition of carbon-free, okay, that would limit your ability to build it. But in return, if we just look at subdivision 4, and you wanted to then fill that with a credit, subdivision 4 says you can go buy a credit that meets the EATS standard. And so if there was a biomass facility in the Big Island of Hawaii that was burning woody biomass, you probably have to dry it out first, but you could buy that credit and meet your standard, and that would be kind of an absurd result where we wouldn't build a facility in Minnesota to do the very same thing. Because it seems very clear, subdivision 4 says, if it's an EATS, it qualifies as a standard to either meet your wind or your solar or your carbon-free. And so that was the part that I saw that was, and you're the one that made me start thinking about it, would be an absurd result of the statute. We don't want that. So is that the way you're reading the statute? Because it was your briefs that I read that brought that to mind. So am I missing something?
Thank you for the question, Commissioner Toomey. I don't think you're missing anything. I mean, I think there's other parts of the statute we also considered, as far including local benefits under subdivision 7 and subdivision 9. But as far as the compliance under subdivision 7 and subdivision 4, I think that's a fair reading of the statute. I think you can get there either. We agree you don't have to. It doesn't have to be ambiguous to get there, as far as the interpretation, and we would agree with the department's opening statement there as well, as far as how this could be considered. But I think your reading of the statute is a fair reading of the statute.
Yeah, and that's what Ms. Payne, I was trying to get clear, because if it creates kind of an absurd result, if they can meet a credit because a plain reading of language has EATS in it under subdivision 4, and if we take EATS out of the definition, which I think is clearly tied in through the compliance statute, it would create that absurd result. And I think we have to read the statute as a whole to avoid such an absurd result. You see what I mean?
Payne.
Chair Sieben, Commissioner Tuma. I do understand what you're saying. I think where I think it's important to be very clear, and I think one of the reasons why the department would argue that we not adopt decision option 1 or decision option 2 is because if you include as a decision option an order point for the commission, what a definition of a defined term already in statute is, you are implying that the statute is ambiguous by stating what the definition is, and you don't want to do that. I think you also run into the danger of when you are trying to parcel these things out as part of a definition, if you are blending the definition of technologies versus what a standard is, because those are two separate things. So I think the best option is to leave the plain language definitions in statute as they are without including any of those in a decision option, because those definitions for technologies and for carbon-free then feed into the criteria that you will create for the standards.
That's my fear, is that we create a perception that we're finding ambiguity here, and I don't want to create that, because I don't think there's ambiguity as it relates to EATS being carbon-free and the carbon-free standard being met by EATS. And so that's where I agree with Commissioner Sullivan, that if we put it in there, if we do put it in there to clarify it, I would want our order language to be very clear that we're not finding it through a line of ambiguity. We're finding it through a line of strength. We're going to the same port, okay? We're using a stronger ship, is what I'm trying to say.
I just want to call it that you were right, Commissioner Tuma. That did help clarify things.
Finally,
so I appreciate it.
It's taken me 3 weeks to figure it out, but
Can I just add it took a while.
I said 15 minutes. I think I was within 15.
Okay.
Can I just, there is one little thing that I want to add, is that like the way that I'm looking at this, and I think we're revolving now around the same center mass, but the utilities all can read the statute. Everybody can read the statute, and they can see the statute. And when a utility puts together their plans, and if they put together a plan that has a particular technology that folks disagree with is not consistent with the statutory framework, then they can argue about that at that point and develop a full record around it. I think that's what this commission is designed to do. And so from my perspective, I think I heard the department say, and I don't think we need 1 or 2. I think we should just go straight to 3, and that's where my brain is at.
And Madam Chair, to the department, this does not preclude us addressing difficult issues like methane or life cycle or carbon. We have 2422, which is the resource adequacy or resource acquisition and resource planning. And in there is a clear mandate that we take in environmental externalities, which include our carbon-free goals. So, Mr. Mueller, when you come to us with your woody biomass facility, it's going to probably end up in a resource plan, right?
Mr. Mueller?
Thank you, Chair Stephen, Commissioner Tuma. We have an IRP that's due March 1st, 2025, and that will likely be one of the options that we consider in that IRP.
And all those parties that are all concerned about trying to use this statute to, reinvent the definition of the statute to get at those things, will have an opportunity in your IRP to bring up alternatives that we'll look at. And we'll look at the cost of your facility, we'll look at its global warming emissions, we'll look at its particulate matter emissions, and likely they're going to come up with a proposal, let's say, for a, solar battery set, and we have to compare then those things using those analysis. The battery thing might be more expensive, but when we throw in the renewable or the externalities, they may start to balance out that the other option is better. And you understand that's going to be the debate we're going to have. So just because it may qualify as carbon-free ain't going to mean you're going to get to build it until you go through a resource plan, right?
That's correct, Commissioner Tuma. I'm sorry, Chair Stephen. That's correct, Commissioner Tuma. I think we were hoping, for that certainty going into the IRP, but we recognize where the Commission's at today too. And we can
But that helps you out because you have a carbon-free asset. You need to get to carbon-free. You're going to try to comply. And what's going to compete against it more than likely is going to be a carbon-free asset, or at least a partially carbon-free asset with maybe credits to be bought. We don't know until we get your resource plan and look at what you're proposing. And that needs to, I think, be read together with this statute to make people understand we're not throwing out all other global warming concerns, but the legislature has told us for this statute and for this measurement to focus on carbon. And that will probably dictate what assets you put into your proposal, right?
I think that's correct. I mean, we also have to plan, and we have the carbon-free standard requirements come very quickly, and so we have to make decisions and have commission implementation of those decisions fairly quickly. But that's correct, Commissioner Tuma.
And that's probably the value of doing this, so we can have this conversation so that utilities like you and Minn Kota and those know that we can proceed under that paradigm, knowing that's going to be dealt with. Well, makes good sense we're doing it.
Commissioner Hom.
Thank you, Chair Stephen. Yeah, all along I was trying to give our utility certainty. That was one of my goals as a commissioner last 7-8 months. But also, I don't know whether our utility will get the certainty because we are going in that route of picking one or two here, because life cycle analysis may dictate that. So practically, we may just need to go into the life cycle analysis first before we do anything. That gives more certainty to our utility. And I think our utility already has a lot of enough flexibility to meet 2030. Either they are already ahead of it, or they know that certain technology can give the no uncertainty there. So even if we are going in the route of giving the utility more certainty, I don't know whether we are giving our utility certainty, because the life cycle analysis may bring more uncertainty after the facts. So that's my concern. That's why I was debating a lot about biomass and the hydrogen issue. And to me, I think practically we need to go into this life cycle analysis as soon as possible. And that's the best way to give our utility more certainty.
That's helpful, Commissioner Hom, and I'm looking at the Department Modified 3. And Dr. Lieb or Ms. Payne, can you help us understand that question then of how the life cycle analysis will fit into resource plans that utilities may be filing before that proceeding is over? Is that, have you thought about that, and what insight can you give us?
Sure, Chair Sieben. The department one of the modifications we made on 3 was to acknowledge that while these dockets that we believe need to happen for further record development are critical, they need to be done in a timely fashion. And that was where we put that the new dockets need to be completed by December 31st of 2025. That was based on discussions with Minnesota Power and when they felt they needed this clarity for their IRP, which I believe is probably the IRP that's most dependent on a life cycle analysis for partial or fully carbon-free resources on a life cycle basis. If the commission feels that a faster timeline is workable, given the commission's calendar over the next year, or one of the other utilities wants to speak up that the end of 2025 is not enough time for their certainty on their resource acquisition or planning, I think we'd be open to that. But I do want to flag that we intentionally put a date there, and that was based on what Minnesota Power felt they needed for their own certainty.
Well, Mr. Mueller, then let me turn to you. You could file something, an IRP, that uses the generation at Boswell, for example, for something that is clearly in the carbon-free bucket, like Commissioner Tuma said, like excess, solar or wind resources. So, and your IRP is due to be filed with the commission in March of 2025. And so help us understand why having a commission make a decision, the commission make a decision by the end of that year after you've already filed your resource plan won't just inevitably delay the resource plan decisions, which to what you answered or to what you said to Commissioner Tuma's earlier point, it is important that we make these IRP decisions on a more timely basis.
Thank you, Chair Seaman. I think our thought is, given how long the IRP process typically takes, that we could build a decision in on the life cycle analysis into that IRP. So we could file it with our proposal on March 1st, 2025, that shows what we think for compliance for biomass, for other items. But then as the commission builds that record, we agree at the department that if we have that certainty to go there or to have that by the end of 2025, we can build that into an IRP process and an ultimate commission decision, which would probably happen sometime in early 2026.
Mm-hmm.
You can't see Mr. Mueller, but you do have a phone a friend that did come to the table, so.
Yes.
Oh, good. Yeah, if Ms. Kuklinski has other additions to that, please do so.
Please state your name for the record and provide any comments on the timing of the IRP and the life cycle analysis, please.
Thank you, Chair Sieben, Commissioners. Jennifer Kuklinski with Minnesota Power. We did file a letter stating that we agree with the department's modified decision options, but we did highlight on the record that time is critical for our IRP, and even getting a decision at the end of 2025 on the life cycle analysis that would be used for eligible energy technologies only leaves us with about 4 years to plan, build, acquire resources for, and get approved, of course, by the PUC new resources to meet the 80% by 2030 carbon-free goal under the carbon-free standard. So it's not just that we're worried about working towards our next IRP and planning for that, but we're also, we want to be able to work towards that 2030 goal as well. And one thing that we did mention in the record because of that timing consideration was, the department offered kind of 2 options, which we greatly appreciated in modified decision option 3, to either develop this record through a new docket or potentially in the same docket. And we thought that a stakeholder work group might be able to get to that LCA faster. But we can live with 2025 if that's what the commission orders.
Sure. Along that lines of.
Commissioner Tuma.
If it's okay, I don't want, I'm looking at the department, you put together 16 and 17. both talking about life cycle analysis. In 117, you state, at the end, you add in to be determined in the second docket. Am I tracking that that is the timing you're trying to establish to help MP?
Chair Sieben, Commissioner Tuma, that's correct. That's referring to that same second docket, and I apologize for the drafting could have been tighter on that.
Oh, no, it's fine. It's, where it kind of confused me because I think 16 should have that same language in it too.
That's correct. 16 should have that same language.
Wait, help me out, Commissioner Tuma. What are you saying again?
So in 17, they added in language under 17 Department Modified to be determined in the second docket, and that was that timing conversation they just had about trying to get it done in a timely fashion. And then when you go back to 16, which talks about biomass life cycle, it doesn't have that reference in there. I'm assuming that's what they meant, but it doesn't have the reference in to be determined by that second docket. So I would assume that they're to be together, and I think that's what you're saying is what the intent was.
And so one more time, Dr. Lieb, what is the department's preference then, that we add that into 16 or that we adopt the other one we were talking about, 3? Or it's both, actually?
The department supports adoption of the department's modified 3 as well as the MPCA modified 16 and department modified 17, which I believe is the same as MPCA modified 17.
Can I ask quick?
Yeah.
So, the department supports PCA's
I ca-
16 over
Let's
the
hear.
department 16?
Let's hear from Mr. Kudelka, who's here at the table. Commissioner Kudelka, on behalf of the MPCA, please state your appearance and welcome, and then if you want to weigh into if you have any preference for the process here that has been discussed, and we certainly will lean into your expertise on these matters concerning the life cycle analysis.
Chair and Commission members, thank you for inviting us. My name is Kirk Adelka. I'm Assistant Commissioner with the Minnesota Pollution Control Agency, and we support what Department of Commerce has been working on, and we work together on this idea of this second docket to provide certainty as folks move into the planning process. And that's where we'd like to further refine, as you see in Modified 17, is that fuel cumulative life cycle analysis, where we would be happy to help the Commission work on the technical nature of that. We are familiar with a number of tools through EPA and others that can help us and you define what are those greenhouse gas impacts as we move forward with that fuel cumulative life cycle analysis.
Okay, that's helpful. So, Dr. Lieb, then you support modified, MPCA modified 16, right? And MPCA modified 17?
Yeah, Chair Sieben, I'm sorry for the confusion. I'm looking at what we filed. I think there's a mistake here in the final decision options.
Okay.
Department modified 16 is not what we filed. We filed an identical decision option to PCA modified 16. So
Okay.
we are supporting MPCA and department modified 16, and the MPCA modified 17, which is identical to department modified 17.
And just to be clear, that would result in a different docket. And I think that just thinking through what Minnesota Power said about a stakeholder group, that's fine if that happens, but I do think that the decisions that will be made here, it seems to me like it needs to be another docket. It can't just be a stakeholder group, so I don't know if that's what you were going to say, but
Yeah, so Chair Sieben, I think the department agrees with you. I think this is one of the things in the meat of implementing this rule, that the commission needs to come up with rules and guidelines for meeting the statute. and that would include this life cycle analysis for these resources. So it would be best in a docket with a formal commission decision.
Okay.
And just so I'm clear, 16 and 17 tie back to 3, the timing of 3. I don't need it. I don't think you need to change the language. I just need to know that's your intent, and that's fine for me.
That's our intent. Happy to let you change the language if you want to clarify, but the intent is that this other docket is all this docket that's discussed in 3 with this
That's all I wanted
timeline.
to make sure. It was a package, and it didn't seem like a package when I read it as it laid out first. But now I know that, so I'm cool.
And Mr. Kudelka, on behalf of the PCA, is there anything else you'd like to add or comments you'd like to provide to the commission? Just as a sister agency of ours, we're welcome to hear them.
Chair and Commissioners, thank you. We agree with what Department of Commerce has been saying. They know the technicalities of the implementation far better than us, but it also fits the overall looking at the whole generation across the state in terms of greenhouse gases and making sure we don't have unintended consequences focusing on one sector and having it increases in others, which would be regrettable overall.
It's helpful. Thank you. Commissioner Sullivan?
I'm assuming we're going to take a break and we'll work through what this 16 and 17 then look like, if I understand it. Are we going to, because are we going to take 16 department modified and 16 PCA modified? Am I hearing that both of those should go forward?
Mm-hmm.
Okay.
That's what Dr. Lieb said.
Yeah, and same with 17?
But we'll take a break, but if,
Yeah, okay, that's all
just to make sure everybody's clear on what, but I don't know if we're ready to,
No, I wasn't trying to do that. I just wanted to make sure that I can put a mental note on that part of the conversation, like what we're going to do there.
yes.
Okay.
Questions from, on different topics? Commissioner Hom?
Thank you, Chair Stephen. So now I think hopefully this is a relatively easier area, that environmental justice area definition portion. So for the department supports 24, but I'm not clear whether the department is supporting 28.
Require utilities. Oh, sorry.
Chair Sieben, Commissioner Hom, the department supports 24. We did not take a position on 28, but we would support 28. Thank you for catching our miss.
Thank you. Based on my quick research, the census tract is not necessarily will cover Indian nation defined in the statute. So I think we have to have additional qualification. I really appreciate our staff finding and focusing that on. Thank you.
Questions from in other areas or on other topics, commissioners?
I would like to, I'd like to talk about market purchases and just hear from the department on their recommendation for the MISO fuel mix. I just want to hear a little bit more about why they're thinking that, they are looking at decision option, which I have 20 for the department. Is the department supporting decision option 20?
The department's supporting 20 or 21.
20 or 21. And I just want to hear a little bit more of like the department's rationale around that. When I think of the MISO market, I think just from an administrative perspective, it is one large market, and we don't know where the power flows are coming from. There are massive power flows into MISO that come from PJM, and it feels to me like the simplest, best approach so that it is directionally correct, is just to look at just the general MISO market. So I'm kind of wondering, why do we want to kind of lock in on zones 1, 2, and 3, or just our particular states?
Chair Sieben, Commissioner Sullivan, the department appreciates the question. In a perfect world, the department would like this law to be implemented in such a way that we move towards time-based environmental attribute certificates for purchase power so that we have more information on what we're buying. We recognize that that's going to require a significant push from both the state's utilities and the power market to fully implement. And I hope that's something we can continue to revisit as we're assessing compliance with this statute. At this time, the department originally chose 20 because I think we are in agreement with you that the power flows are not perfectly well defined, and at the end of the day, this is a back of the envelope calculation of how carbon intense the purchased generation is. There's a number of stakeholders that prefer 21, which is why we're agnostic to 21 if the commission believes that based on the generation ties, this is a more appropriate representation of the mix that's coming into the state. Recognizing that neither is really going to be totally accurate.
Along that, Madam Chair, Mr. Sullivan, I could just because I want to track on that because I was confused with you a little bit to it. Is your vision is that this is an annual analysis? They'll come and do an annual filing, and they'll look at the annual mix of MISO, whether north or the whole of the region, and either MISO or they'll have to produce some sort of carbon intensity score for that annual purchase. So they might have bought 20 megawatts in June, and it doesn't matter if all that was wind in June, okay? It's going to be that whatever the overall mix was on an annual basis, what you purchased. And yeah, you bought it in June because it was real cheap and you wanted to buy it, and it was all wind, but sorry, you get the annual mix at that stage. Is that my understanding?
Dr. Lieb.
Chair Sieben, Commissioner Tuma, I think, again, recognizing that this is an imperfect accounting methodology, the department's hope would be that overall these things should work themselves out, that sometimes you're buying during a peak period of low wind and solar output in the market, you're buying mostly fossil. During a period of time when there is excess wind on the grid, you're buying mostly wind. A lot of the times, our understanding is that these are unspecified power purchases, so it's not clear exactly what you are buying once something gets into the MISO system. So recognizing that this is an imperfect calculation, that we would like to see additional build out of tracking mechanisms in the markets to understand what we're buying. But right now, unspecified power is unspecified. So we're recommending that we do it on an annual basis, except in the case of specified power purchases, which I think is our new 34,
Right.
that if the power is from a specified resource, it should receive an appropriate carbon intensity. And I think it's decision option 19 where we're recommending there is further record development needed here, possibly in the next iteration of this docket or this issue. That's where we want to look at also the netting of the sales and the purchases. If a utility is selling off a bunch of excess wind at a time where they have excess wind available, we want to make sure that we're accounting for that appropriately when we're netting out sales and purchases as well. But I think that that's better moved to a separate docket.
So based on whatever's happening in the RECs market, I would probably be better off if the RECs are high to be buying a bilateral agreement under that paradigm and getting locked in on renewables, which is a good thing because we're now then supporting a renewable purchase probably someplace regionally as opposed to just leaning on the market. But that would depend on the cost of RECs. If the RECs are cheap, then I'll buy the power and run with that. Got it. Thanks, Joe.
Do commissioners have other questions for the parties? Otherwise, I would propose that we take a break to allow commissioners to gather their thoughts and come up with a proposal. I think I've been pretty clear over the course of the afternoon that I'm following largely aligned with where the department is and am supportive of that. I'm not going to make a motion when we come back. So if someone else wants to do that and work on it, Commissioner Sullivan, you've sort of been tracking the latest iterations of 16 and 17. Would you be prepared to make a motion? And I'm turning to you because I heard you say things that I agreed with earlier, so.
I would be prepared, I will be prepared to make a motion.
Okay, and do any commissioners want clarity from parties about where they're at on the latest filed decision options? Okay, how much time do you need to put together a motion, Commissioner Sullivan?
15 minutes?
Okay, the commission will.
Well, how about 30 minutes? Let's do 30 minutes, just in
Okay,
case.
how about the commission stands in recess until 2:30? We're in recess.
30-ish. So Joe.
The commission will come back from its recess, and if folks could please be seated and be quiet, we'll proceed to see if commissioners have further questions for the parties before moving into deliberations. Any questions from commissioners for the parties?
I do.
Commissioner Sullivan.
I have 2 questions for the Department of Commerce. Regarding the decision, Dr. Lieb, Ms. Payne, I don't know who's going to take it, but regarding decision options 16 and 17, could, Mr. Whitty, do you have the new language?
The revised decision option
The revised decision
language?
option?
Is that what you're asking?
Yeah, the revised. I just want to see if you are okay with this. Well, I'll just jump out, is that if you can see revised 16-17 staff,
I cannot see.
okay. This would replace both 16 and 17.
Wait, and you're doing that because you just think it's an easier way for us to understand what 16 and 17 said, or is it changing any portion of what?
Correct, it's not meant to change
was.
it. Staff and we worked on this. We could also just do, is the department comfortable with Pollution Control Agency modified 16 and 17? Is that your preferred now?
Let's start like this. Mr. Whitty, will you please put up MPCA modified 16 first? So scroll up a little bit, I think. Is that what you want? We're asking. So Dr.
Yep.
Lieb, do you support, Dr. Lieb, do you support, I think you said earlier that you did support this, or that's what my notes indicate, but is this the right language for 16 that the Department of Commerce is supportive of?
Chair Sieben, that's correct. MPCA modified 16 is what the department is supporting.
As amended. And then Commissioner Sullivan also wants to know if you support MPCA modified 17?
Correct, yep.
Yes, the
If you
department.
could scroll to that, Mr. Whitty, just to make sure we're looking at the right language.
The department supports MPCA modified 17.
We'll just stick with that. We can just.
Okay, and then I just want to be clear that the second docket is only for this, for 17, correct? Commissioner Sullivan?
Correct.
And the 16 modified, MPCA modified 16 is what it says, but
So
it's
Dr.
not
Lieb, I want.
talking about a second docket.
Chair Sieben, Commissioner Sullivan, the department's language in 3 is intentionally meant to be for combusted fuels receiving partial or full carbon-free compliance credit, and that should include things like hydrogen and the biomass, renewable natural gas, solid waste. But we intentionally left this sufficiently open-ended. If stakeholders wanted to also introduce things like green ammonia, synthetic methane, we didn't want to restrict the fuels that should be considered for life cycle analysis in the event that their utilities want to bring forward things in that docket that we may not have thought of and called out explicitly.
So, okay. Okay. So there is the connection between decision option 3 and 16 and 17. Now, the department right now is recommending decision option 3 as modified, which includes A, B, C, and D.
That's correct.
And then that, along with department modify, or PCA modified 16 and PCA modified 17, directionally, that is where you want to be.
Chair Sieben, Commissioner Sullivan, that's correct. The intention is to make sure that we're supporting Department 3 modified, that that A, B, C, and D need to be discussed in a separate docket. And 16 and 17 are meant to clarify that we do intend to discuss biomass and waste in those dockets and RNG as discussed in these decision options.
Not to take over Commissioner Sullivan, but
It's okay.
Dr. Lieb, in Department Modified 3, it says delegate authority to the Executive Secretary to commence record development in this docket or a new docket. And I just heard you say a new docket. Are you ambivalent, though, on whether it continues in this one or in a new one?
That's correct.
Okay,
But we'll
just making
leave that
sure.
up to you and
That
the
makes
Executive
sense.
Secretary to do what makes the most sense.
So then that answers that question. I know what I'm going to do there. And then now, Dr. Lieb, decision option 34, department new. There's an awful lot of crossover there with decision option 23. And I'm wondering if you could, does 34 address the issues raised by decision option 23 in your mind?
Or would we do both?
Or would we do both?
Chair Sieben, Commissioner Sullivan, from the department's perspective, 23 is more process focused, that we need to acknowledge that further record development is needed for this. The department added 34 as this was something that we explicitly advocated for in our public comments, and some stakeholders advocated against treating specified power purchases based on the actual carbon intensity associated with that purchase. So we would prefer that when this discussion begins out of 23 for further record development, we start from a place where the commission has already decided that for specified power purchases where we know the carbon intensity of those energy units, that we do not need to rehash the issue of whether or not those should be assigned an appropriate carbon intensity.
And just to be clear, that would then occur through decision option 3, correct? Like that would be the process? Is that what you're?
I think from the department's perspective, that could happen in 3, or that could possibly happen in the next docket, which is aimed at compliance discussions. I think we'd be,
Okay.
as long as that, we recognize further record development is necessary there, but I think open to the commission on where they think it fits better.
Okay. I think I know.
Flexibility.
You're ready?
I'm ready.
So any further questions from commissioners? Otherwise, Commissioner Sullivan will step us through a motion, and then we'll discuss it.
All right. Thank you. And I do want to start off by saying I very much appreciate all of the parties who have worked on this docket for a while. We have a full record. This record is voluminous, and I have carefully reviewed it, and I appreciate all of the work that has gone into it. I want everybody to know that on the front end. So my decision option, or my motion, will be to move decision option 3 in its entirety.
Department modified?
Department modified, thank you. Decision option 9 as modified by the department. Decision option 14 as modified by the department. Decision option,
Slow down.
oh, sorry.
When 14 department modified that
Yeah,
last.
yeah,
one.
I'm reversing, I'm sorry. Department modified. 14 department modified.
You didn't do 4 department modified.
I did not, no. Can I go, okay. Decision option 15 from the CEOs. Decision option 16, the Pollution Control Agency. Decision option,
Wait. 16 is MPCA modified 16.
correct.
Just let Mr. Woody catch up.
Decision option 17, MPCA modified. Decision option 19, Department of Commerce. Decision option 21. Decision option 22A. Decision option 28. And decision option 34. And
34, Department New.
yes, sorry, thank you, Department New. And that is my motion. I'm happy to discuss, happy to answer any questions, and I do want to thank the Department of Commerce for all of their work on this and helping guide the process on this statute. I appreciate the administration's involvement in the matter, and same with all the other parties. Thank you.
Commissioner Hom, is that what you were thinking around the, or is that what you wanted to do around the environmental justice areas?
Yes, I think that's a direct translation of the statutory requirements, and then I compare census tract and then reservation. I found at least the two part I checked, there's a potential ambiguity. So the 28 clearly addressed that.
Great. And Commissioner Tuma?
I just wanted to thank Commissioner Sullivan. I agree with the decision option. Just to make sure we're building it off the base of that this statute is not ambiguous. It is unambiguously clear, and that's the foundation we're building off of. And I think that's where we started from, and I think that's important to point out that where the department came from was that message here today, and I appreciate that.
Commissioner Means?
Thank you, Chair. I don't have much additional. I came in today thinking that there would be a lot of conflict around whether the key terms were ambiguous or not. And I got to the avoidance of an absurd result in a different way. But I think this is a very reasonable path forward, and I support your motion.
Commissioner Sullivan, thank you for your leadership here and helping guide the commission to a path that we all agree on. I think it's worth stating what I said at the beginning, and I know we all agree with that the credit for passing one of the nation's strongest climate laws lies with the administration of Governor Walz and Lieutenant Governor Flanagan and the hardworking legislators and advocates who worked for its successful passage in 2023. And we here as regulators are here to implement that law and ensure that Minnesota continues to have reliable and affordable power while also increasingly carbon-free. So I echo the comments that others have made that we appreciate everyone's support and record development on this matter, and we'll continue to rely on it in the dockets that will precede this and the additional issues the commission will take up on this matter. So hearing no other discussion for our order writer, the order's clear. And to the department, are there any clarifications or things that you wanted to add? Great. All in favor of Commissioner Sullivan's motion, please say aye.
Aye.
Aye. Opposed? The motion prevails 5-0. Thank you, everyone. We are adjourned for the day.